Chair, very well noted.
Yes. Any further question?
Thank you, Mr. Chair. I have no follow-up question, but I have a second question for my Lord. My Lord, there is a troubling trend of people using social media to abuse or defame other people. Some hold the view that suing them and awarding damages against them amounts to curtailing freedom of expression. Do you agree with this position, my Lord?
Thank you, Mr. Chair. Mr. Chair, the Venerable Justice, a well-known justice known to everybody who has studied the law, the name just escaped me, from Britain, and I'm sure by saying Venerable, all of us remember him. In the case of British Steel Corporation versus Granada, said, Lord Denning said, freedom, if you want to deserve freedom, the press deserving freedom, they must work for it, because free speech is not taken. In Pakenham and North Carolina, Justice Scalia said, acting on social media, it is like the old style writing in newspapers. Therefore, there must be some guidelines there. So if you go on social media and you use that to abuse somebody, and the person thinks that he's defamed, I think that going to the court will not be gagging anybody. There must be responsibility. People must be responsible on social media. Thank you.
Any further question?
Yes, Mr. Chairman. No follow-up question, but I have a third question. My Lord, my final question to you is that some people argue that the practice of empaneling judges by the Chief Justice allows the Chief Justice to favor certain judges for particular cases. I'm talking about in the Supreme Court. Do you think something should be done about this particular situation? Thank you.
Thank you, Mr. Chair. I think the Chief Justice and paneling judges is an administrative work. But the question you pose also gives me the impression that there's that perception that a Chief Justice can use that negatively or select something. My view is that we should have a statutory legislation about electronic empaneling. Even at the Supreme Court, there should be panel heads with the Chief Justice as one of them. Because my understanding is that at the appellate court, there are senior judges, middle senior judges, and junior judges. So that if you have panels of, let's say, 4 at the Supreme Court, with the most seniors as the heads, and cases are assigned electronically, and it goes to panel 1, which is headed by Judge A, then it cannot be changed. It will help to take away the perception of abuse of a Chief Justice using paneling to do favoritism. That will be my answer. Thank you.
Any follow-up?
Mr. Chairman, there will be no follow-up. My Lord, congratulations, and I wish you well. That will be all for now.
I'll proceed to give the floor to Ackaah-Boafo Jr.
Thank you very much, Mr. Chairman. Congratulations, my Lord, for the elevation. My Lord, I believe that when the bench is filled with incompetent judges, they will deliver low-cost decisions at the expense of the citizenry that we represent. In your view, how do we monitor and eliminate incompetent judges who see the bench as a benign retirement from the rigorous private practices that we have?
Well, thank you, Mr. Chair. Incompetent judges, I think that to be elevated to any of the benches, individuals go through processes. So once they are appointed, they are presumed to be competent. Now, the judiciary certainly has an assessment section that they assess judgment. I work at the JTI. There are times that a judge may err, that a reference may be made for judges to be retrained at the JTI. And I think that is one means of assessing whether or not people's knowledge in a particular area is not good. But we know the rules for appointment. Once the person is qualified and it's a lawyer and is appointed, there's a presumption of competence. And so it is just an issue of building capacity. Thank you very much.
Follow up, Chair. The conversation for the Ghanaian people is justice delivery. That seems to accord to the benefit of the people we represent. And so it is not just only a matter of the appointing process, but a form of assessment that assures us that judges, whether in their promotional, whatever, is based on competence. So from the Supreme Court that you are going to, what are some of the recommendations in terms of monitoring to establish that competency outweighs any other consideration for appointment?
I honestly believe in an independent judicial commission for elevations and appointments. And that commission, if it's put in place statutorily, would then consider some disappointment. They will assess your work, they assess what you've done, what you are able to do, and that will become the basis. And by the way, in other jurisdictions, you can't even be a judge without voluntary work that you have done, for the community to see that you've served them prior and you can serve them on the bench. So I think that that's one way of assessing competence. Thank you.
Honourable members, as we want the nominee to be brief, we should also be brief in setting the foundation for the question. I'll give the floor to Ackaah-Boafo.
Congratulations, my lord.
Chairman, with respect, not to chip away your powers, but I plead with you to allow things to flow.
My lord, you stated that the population of Ontario is 14 million, and they have 57,000 lawyers. 56,000 lawyers. The size of the Ontario economy is $887 billion. The size of the Ghanaian economy is $8.83 billion. $82 billion. Don't you think that the demand for lawyers in Ontario is driven by the size of their economy as opposed to the population of Ontario?
Thank you, Mr. Chair. I think that is part of the analysis, but the Ghanaian economy also call for judges in this nation. Let's be honest. West, Western, North. I'm not sure they have more 5 lawyers there. And it's a regional capital now. You have lawyers work there. So I think that there's a need for that increase in our space as well, because businesses, district assemblies, and private individuals certainly require the services of lawyers. Thank you.
You know, I'm going to ask a follow-up. My lord, in the 80s, one of the busiest places for legal practice was Western Region, particularly Takoradi and Kumasi, because the economies of these places were booming. And so legend has it that some of the best lawyers, in fact, judges of this country, practiced either in Kumasi or Takoradi. And at the time, their population was very small. And so, by way of follow-up, don't you think that the emphasis really and truly is more on economy than the size of the population?
Your contention is right, but you also recognize that for some time now, Ghanaians have become aware of their rights. I mean, look at growing up, there were only few high courts. They were only based at the regional capitals. Now high courts are district capitals and other places. If the courts are there, people understanding their rights will go there. And sitting as a judge, knowing that somebody self-representing is one of the challenges any judge will face. So I think the economy is a consideration, but the population as well, knowing that they have somebody who can advocate for them is also very important. Thank you.
Well, Honorable Imie, you have the floor.
Thank you, Mr. Chairman. Congratulations, my lord, and welcome to the committee. My lord, we'll start with judicial integrity. You would agree with me that judicial integrity is very important to sustain the confidence of the public in the judiciary. Can you tell this panel, how have you, as a judge since, I think, 2015, when you were appointed to the bench, maintained your integrity? Thank you.
Thank you, Mr. Chair. I think the judiciary, I will call it the arbiter of the nation. And therefore, the presumption is that when people have been entrusted with power to administer justice, they ought to be ethical. Judges have code of ethics, and that is what is supposed to guide us. How have I done mine? I think that I find this as a fulfilling opportunity to serve this nation. And to serve the nation means that I must strive to be unashamedly ethical. And being ethical means that you guide your integrity in doing your work. Thank you very much.
Now, as a justice of the Court of Appeal, if you should discover misconduct from a fellow judge, how would you approach that?
Well, if it is a misconduct that calls for a report, certainly I think that even as lawyers have obligation to report their colleagues who are caught in misconduct to the General Legal Counsel. As to whether or not they will do it is another matter. Because anytime I pose this in classroom, the student go, no. So, but if I see a judge in a situation like that, which calls for a complaint, I think I will speak to a senior judge about it. And if it is something that can be resolved without making official complaint, that will be done. If it ought to be officially complained, I will do that. Thank you.
My lord, in your view, we're going to a different area, AI. In your view, as a justice of the Court of Appeal, do you think the judiciary is prepared or poised to use artificial intelligence as evidence in the determination of cases, considering the fact that these days it's so easy to generate anything?
I will highly recommend the judiciary to be AI literate. The judiciary of Ghana must endeavor to make the judiciary AI literate, because that is the new trend. However, we need to be very careful engaging this, because if we are all literate and as to how it operates, then we are in the front end, and then we'll be able to know the dangers associated with it. Many countries like Canada and UK have guidelines for judges. And so whilst I recommend that AI literacy should be embraced by the judiciary, then we'll be required to have guidelines to guide judges, so that when lawyers are found processes with hallucinations, we'll be able to know it and address it. Thank you.